All right, let's go ahead and get started. Thank you very much, everyone, for joining. I'm Erica Lai. I'm counsel at Coie Gresser LLP, here in my capacity as president of APABA-DC. APABA-DC is thrilled to put on this timely program on preserving voting rights during the pandemic. We're thrilled to be joined by three attorneys who are really leading the charge to protect voting rights across the country. I want to give a special thanks to our education team, James Billings-Kong and Lloyd Liu, for spearheading tonight's event, and of course to our fantastic panelists, who I will be introducing very shortly. So APABA-DC, just for those of you who are not familiar with us, it's the oldest Asian American Bar Association in the DC area, and our three-part mission is really quite simple. Since 1981, we've aimed to serve as a voice for the APA legal community, to elevate and promote the advancement of our members, to facilitate opportunities to give back and collaborate with other community organizations. If you want to learn more about our bar and join us, you can check us out at apabadc.org. Tonight's event really falls squarely within our mission and what we as a bar association care about. Asian Americans are the fastest growing racial or ethnic group in the United States electorate. And yet in the last presidential election, it had one of the lowest rates of voter turnout. It is critical that all Americans, including Asian Americans, make our voices heard at the ballot box, especially in the 2020 presidential election, which could really not have higher stakes. It is fitting that tonight's event is not just put on by APABA-DC, but also in partnership with a number of other organizations in DC and around the country. And I want to thank each and every one of our co-sponsors for helping us spread the word and for joining us tonight. And our co-sponsors are the National Asian Pacific American Bar Association, the Asian American Bar Association of Houston, the Asian Pacific American Bar Association of South Florida, the South Asian Bar Association of DC, the Thai American Bar Association, the Vietnamese American Bar Association of DC, and the Georgetown and GW APALSAs. Before I get this panel started, I did want to share information on a great initiative called Free or Vote that was shared with us recently and was co-founded by Georgetown law professor Neil Sukame. Free or Vote is a nonpartisan organization of data scientists, economists, and legal researchers who are seeking to re-enfranchise 26,000 Florida residents with past felony convictions. Although Floridians overwhelmingly passed a ballot initiative to restore voting rights to individuals with past felony convictions, the legislature passed laws preventing these individuals from voting if they have outstanding fines or court fees. So Free or Vote came up to raise funds to pay off these fines or fees to enable Floridians to vote. If you want to find out more about the initiative, you can go to freeorvote.com. So now, turning to tonight's panel, we will be focusing on the impact that the pandemic is having on the upcoming 2020 election. We'll talk a little bit about some of the critical battles being fought right now across the country to protect the right to vote, especially in some battleground states. I'm sure all of you have been reading all of this with interest. And we'll also talk about the general landscape of voting rights and election law. I'll keep the intros of our panelists brief, just so we can have as much time as possible for the very important topic at hand. So our first panelist is Sophia Lynn Lakin. She's Deputy Director of the ACLU's Voting Rights Project. Sophia has active cases protecting voting rights and combating voter suppression across the country. She is currently litigating a number of cases to ensure that all voters are able to cast their ballots safely during the ongoing COVID-19 public health crisis, including in Georgia, Missouri, and Tennessee. Uzoma Nkwonta is a partner in the DC office of Perkins Coie, focusing on voting rights matters, including redistricting, Voting Rights Act vote violations, constitutional challenges to electoral systems, and restrictive voting measures in cases implicating First Amendment speech and association rights. His recent work has included challenging voter suppression efforts in Florida, Missouri, Texas, and Wisconsin. And last but not least, Avi Panth is Deputy Voter Protection Director for the Biden campaign in Virginia. He is heading up efforts to expand access to the ballot box in Virginia, including voter protection efforts, as well as to prepare for litigation to challenge efforts to suppress and intimidate voters and disenfranchise Virginia voters. And I'll add that APABA-DC and none of the bar associations here support any of the campaigns. That said, we're really thrilled to have all three of the panelists today. We are recording this evening's panel, which is why you see the little recording icon at the top right of your screen. And we're doing this so that we can make the recording available on our YouTube channel after the event for any folks who are not able to join us this evening. So let's go ahead and jump in. Of course, efforts to disenfranchise voters and suppress voting are hardly new. It's something that we talk about every time there's an election cycle. But Sophia, before COVID hit, if you can get us started, what types of issues were you seeing at the beginning of the year? What were your expectations and what were you thinking that you'd be focusing on this 2020 cycle?
Sure. So, we were focused pretty much on our traditional, what I'd call our traditional work, fighting voter suppression and working on making voting accessible, ensuring fair and equal access to the process, equal treatment in the process. And generally, at least at the beginning part of the year, the first couple of months, trying to clear our plates so that we could focus on the kind of more last minute style litigation that and election protection work that typically accompany any election year, but especially a presidential election year. So we had a number of different cases that we were trying to sort of wrap up. We had a case in Tennessee challenging third-party voter registration restrictions, so restrictions making it very difficult on organizations that help people get registered to vote, and they were particularly onerous ones that were being placed on organizations in Tennessee. We won a preliminary injunction in that case. The law was changed. That was good news. In Indiana, we were challenging an illegal voter purge, which had been going on for about 3 years at this point. They kept changing the law, and we were trying to wrap that up as quickly as possible. And in Kansas, we were still waiting on an appeals decision in our case challenging a Kansas documentary proof of citizenship requirement for voter registration that had blocked tens of thousands of Kansans from being able to be registered. And we had gotten that decision in the sort of spring of 2020, and we were hoping to avoid a cert petition, but it appears we are now dealing with a cert petition. So these were some of the things that we were looking at, but one of the big items on our list was this trial that we had coming up in what you just talked about, which was a challenge to the Florida law that creates these wealth-based hurdles to voting. We had a trial set for early April, but by then the reality of the pandemic had hit, but instead of totally suspending this trial, we had it postponed to about 3 weeks later. And it was certainly our first fully remote trial, maybe one of the first of this size in the country at the time. And we needed those extra weeks to, for example, send laptops and MiFis to some of our clients who are going to be testifying because, of course, they're not in position to own such technology, and prepare them for this kind of, intense experience where you usually get to walk them through this hand, like holding their hand quite literally. So that trial did go off. It was going to be probably the biggest effort that we had this year before we sort of focused almost entirely on preparing for the election and some sort of background work that we were doing on redistricting. And of course, COVID happened, but we still had this trial, which we prevailed at. But as folks probably know at this point, unfortunately, in September 11th, a wonderful date, the 11th Circuit en banc overturned the lower court's decision there. And so, unfortunately, groups that are working hard to ensure that individuals who still have outstanding fines and fees that they need to pay will continue to have to do so in order to vote in this upcoming election. So thank you for all the help working with that. But those are the kinds of things that we were working on before, which we would always be working on had COVID not really hit. So just a handful of those litigation options.
What a whirlwind. Uzoma, I'm guessing that it was pretty busy for you even before COVID hit as well. Do you mind giving us a bit of a preview or sort of overview of the types of things you're working on? Think you're still muted.
Off to a great start. So I think the first thing that really struck me, taking a step back and looking at the COVID-based litigation, is that we were litigating a lot of the same things even before COVID hit. I think that the COVID-19 pandemic has just brought to the forefront some of the ways in which state election laws and restrictions to the ballot can actually prevent people from voting and under normal circumstances. And those effects are even worse when you have a global pandemic. So just to give you an example, we have challenged in a number of states signature matching practices that require election officials to compare the signature on a ballot to a signature on file. And election officials sometimes reject ballots for that reason. And sometimes they provide notice, sometimes they don't. Sometimes they give an opportunity to cure, sometimes they don't. And we've been challenging those types of provisions actually since 2016. Did so again in 2018, and we had several lawsuits. One in Michigan. We also had one in Arizona as well. And in addition to those types of challenges that try to prevent the arbitrary rejection of absentee ballots, we also challenge structural barriers to political participation. So in that bucket, I would place our redistricting cases there. And I'd also place, one more unique challenge that we asserted. It was a lawsuit in Mississippi, and we challenged the Mississippi Constitution's three-part system for electing statewide offices. So in order to be elected to statewide state offices in Mississippi, you would have to win the popular vote and a majority of all the districts in Mississippi. And if you did not win both the popular vote and the majority of all the districts, then the legislature would get to pick the winner if no one captured both the popular vote and the majority of legislative districts. Now, we were able to uncover some through the legislative history behind that constitutional provision, which was enacted during the 1890 Constitutional Convention. And we were able to determine, based on statements made in media and letters written to the media by delegates to that Constitutional Convention, that one of the major purposes of that provision was to prevent African Americans from being able to exercise any control over the legislature, or from being able to consolidate their power to elect a candidate of their choice. And at that time, the African American population was growing in 1890, such that the African American population was getting to the point where it would be able to elect a candidate of its choice. And as you know, African American men at the time had been recently enfranchised. So we were able to challenge that provision that had been in place since 1890. And recently, the Mississippi legislature passed a ballot initiative that will now be placed on the ballot in November, which will allow voters to change that constitutional provision and to eliminate at least the requirement that you win a majority of districts in order to win state office. So that's sort of one example of the types of structural challenges that we asserted back before COVID, and that case is still ongoing. It's currently stayed pending the results of the ballot initiative to amend the Constitution, but hopefully, hopefully that will result in positive change. We had some late-term redistricting cases challenging the way the congressional districts have been drawn in several states, including Georgia, Louisiana, and Alabama, and that, in addition to some of our challenges to electoral procedures and practices that burden the right to vote. And then COVID hit, and some of those challenges just took on renewed and heightened importance. And so, in addition to the fact that voters are having their ballots rejected for reasons that are not entirely error prone. We've also challenged the receipt deadline. So, a voter has to, in many states, has to have their ballot delivered to election officials by a certain time, by 7 p.m. on election day, or by the time the polls close on election day. Even before COVID, we were challenging those laws because there are a number of reasons why a ballot may not arrive that have nothing to do with the voter, right? Postal service delays, as we all know, but also just election officials' ability to process the ballots in a timely fashion to get them out to voters, to get them back. And when COVID hit, that took on renewed and heightened importance. And so those are just some examples of the laws that we've challenged before and after COVID, and that we're continuing to try to attack in order to make sure that voters are able to get their validly cast ballots counted.
Thanks very much, Uzoma. I just want to pick up on that last point that you mentioned in terms of administration of elections. And I know that, Avi, you have a lot of experience with this on the Virginia side. Obviously, COVID has changed the landscape in so many different ways. How has Virginia responded in terms of how it's modified its election rules, policies, and procedures in light of COVID and the rules and so forth they've had to enact in order to accomplish that change?
Yeah, thank you so much, Erica. In Virginia, and I'll say first that my view is a little bit narrower than Sophia's and Zoe's, because really I'm just focused here on Virginia and more on the election administration side of things. But here in Virginia, I mean, look, Democrats passed a number of bills even before the pandemic hit that would drastically expand franchise. I mean, the expansion of absentee voting and elimination of various roadblocks that made voting difficult even before COVID was around. So as an illustrative example, the photo identification law was something, a lot of states, especially in the South, still have those requirements. Earlier this year, Virginia did away with that. The expansion of no excuse absentee voting. They also made Election Day a state holiday, expanded poll times by an hour. So there was a good foundation even when COVID came into place to be able to ramp up. I'd say the challenge in Virginia has been less about the availability of needed laws. It's been more about rapidly changing the election administration posture to be able to account for those new laws and implement the new law. Here in Virginia, I mean, we have really good election administration officials, but you have 133 different localities. Each is in some ways its own fiefdom. They march to their own drum, although they are coordinated, but each one has sort of a unique set of challenges. And now, given the surge of vote by mail that COVID now has pushed folks into that direction, a lot of localities really, quite frankly, struggled to very quickly ramp up the capacity to go and deal with that, whether it's hiring new election officials. A lot of the folks who historically have been election officials or officers of election, as we call it here, we're a little bit more reluctant to participate in the election this time around. And so finding a new pipeline for people to work in the elections offices. And so, I mean, there have been a number of challenges with COVID itself that I can talk a little bit more about if it'd be helpful, just in terms of the precautions that these very well-meaning registrars are trying to take, but can inadvertently lead to folks' vote being disenfranchised. And so, I'd say at a high level, the challenge that we're seeing, at least here in Virginia, is, not so much the law itself, but how do we implement the law in a way that, for the first time, how do we make it go off without a hitch?
No, that's great, Avi. And I do want to come back to that point that you just mentioned about how difficult it is to actually implement the new election laws. But to back up a step in terms of talking about how COVID has affected litigation and just the voting rights landscape and the like. Sophia, I know that you were involved in efforts to work on ballot initiatives prior to COVID, and that work might have had to be affected in light of COVID. So can you tell us a little bit more about what ballot initiatives you were working on and how that was impacted by the recent events?
Yeah, sure. So, I mean, one of the sort of silver linings I always like to talk about are these ballot initiatives that we've been working on since 2018. We had great successes in Michigan, in Nevada and Florida with ballot initiatives, and Maryland expanding access to the right to vote, making it easier and more accessible. And we were hoping to do so in 2020 again, both in Ohio and Arizona. And unfortunately, because of COVID, meeting the petition signature requirements was proving to be quite difficult. And even if we were able to sort of prevail in court, which was not looking so great in its own way in terms of getting some sort of relaxation onto the signature requirements, even getting people to back up and moving and motivated, and the signature gathering process through maybe a remote means or however this was going to happen was proving to be difficult. So it's something that we had to put on hold for 2020, unfortunately. But I do continue to believe that it is a great way for voters to have a say on how accessible they want the process to be. And, you know, time and time again is demonstrated that if you put it to the voters, that they overwhelmingly do want these reforms that really do make it a little bit, it's common sense for the most part, and reduces, I think, unnecessary barriers for people to access the ballot. So I continue to be hopeful that this is an avenue for where ballot initiatives are available to expand the right to vote, even where other avenues seem maybe a little bit more difficult.
That makes sense. And I assume you had to shift gears from the ballot initiatives to new challenges you had to file to make sure that there was a widespread access to voting by mail. So Sophia, can you tell us a little bit about the work that you've been doing in that arena?
Sure. You know, I don't know if we switched gears so much as just put it on top of everything else that we were doing. Sure. And I think like many other voting rights groups and Uzoma, I know we'll talk about some of his efforts as well. We focused a lot on making voting by mail more accessible, more available, using both advocacy, litigation, and sometimes the two together. With our network of affiliates on the ground, a lot of places, sometimes it really did make a difference to kind of use a concerted effort with our local connections on the ground, and then the sort of hammer of the bad press from litigation sort of behind that. And it just made sense to us at the beginning of the pandemic to focus on making vote by mail accessible and more available. So like I said, that's kind of where most of our efforts have focused. We filed, I think all told, 26 lawsuits since the beginning of the pandemic in 19 states and Puerto Rico. Now there's only a handful of states. There were 16 at the beginning of this, 17 if you don't include Virginia, which now has no excuse vote by mail left. And that's been a combination of efforts from all the different groups that have been participating in this, as well as states themselves kind of seeing the light and understanding that it made sense to give voters as many options as possible. One specific area that I'll just mention, I know there are tons of other areas that we could talk about just during the pandemic, are the sort of subset of requirements for voters who do vote by mail. And even if you have access to vote by mail, what we were seeing was that a number of states still had an additional secondary requirement that kind of defeated the purpose of mail voting. So for example, a witness requirement or a notary requirement or an identification requirement. So for first-time voters who didn't have an ID, did they have to find an ID at a shut DMV? Was that even possible? And so we challenged these requirements in 9 different states, a mix of state courts and federal courts. And while we've had some court successes and we're still watching a few that are kind of running out the appeals process right now, I would say that the more hardy successes that we've had were through consent decrees which we were able to get in Virginia with the witness requirement there. And Avi can talk a little bit more about that, in Rhode Island and Minnesota, or voluntary action on the part of the state in other ways, like in Kentucky, which went ahead and kind of took a lot of actions on their own, sort of in the midst of our lawsuit. And even in the case of the consent decrees, I mean, this has been a hard fought battle. I know we'll probably talk a little bit about that. We have been fighting tooth and nail for these, like I said, common sense solutions. So even these consent decrees were appealed all the way up to the US Supreme Court. So in Rhode Island, for example, which was a consent decree, where the state agreed to put this into effect, that was appealed to the US Supreme Court. And it resulted in one of the few cases where the court has permitted a court-ordered COVID voting change to remain in effect. And that just kind of demonstrates, I think, the sort of battle that has been fought throughout the last couple of months just to make voting safe and accessible for voters, which is really troubling in a lot of ways. But I know, there's been a lot of effort there. So I hope folks know that there've been a lot of people fighting for this effort across the board. And hopefully we've done some good here.
So I think that Sophia teed it off for you. So you want to talk about some of the efforts that you've been working on in terms of expanding access to vote by mail?
Sure. So I think a lot of our efforts have been similar in terms of focusing on expanding the right to vote by mail and removing the barriers to doing so, and also working on challenging restrictions on how those ballots are counted and how those ballots can be received. In addition to that, we've had quite a bit of defensive litigation as well, as Sophia alluded to, because not only are we litigating in states to try to implement these reforms, but we're also intervening in cases where either the RNC or the Trump campaign or a different campaign has filed lawsuits to try to prevent those measures from being implemented. And so I'll give one example is Pennsylvania. And what we're seeing there is that the theory of vote dilution and the theory of equal protection injury sort of is being advanced by both sides. In those lawsuits, the individual voters claim that providing these avenues to voting for others who may need it potentially dilutes their ability to vote, or potentially denies them equal protection under the federal equal protection clause. And so we're challenging, or we're pushing back against those claims, intervening as defendants in a number of those lawsuits. So I mentioned Pennsylvania. Another one is Nevada, where we've seen that occur. There have been some lawsuits in North Carolina addressing that similar issues, raising similar claims. We actually just recently saw decisions coming out of the Pennsylvania federal court and Minnesota federal court rejecting those claims. And I think that those courts have upheld the typical understanding of vote dilution, which is when your vote, when an individual's vote has been afforded less weight or has been denied, or the right to vote has been infringed upon in some way, not as a weapon to try to prevent someone else from voting, and not as a weapon to try to prevent easier restrictions or to try to make mail voting more accessible to others. I think, and something that these courts have also recognized is that the specter or the myth of voter fraud itself cannot be used in speculative fashion to try to preemptively prevent the expansion of vote by mail, or to preemptively prevent a state from making voting more accessible. And then that's something that we have seen, that when states, at least during this COVID pandemic, when different states have tried to expand voting by mail, or courts have implemented certain relief, you see some pushback. on the basis that this may open the door to fraud, and this may make it easier for people to fraudulently cast mail ballots. And there's a lot of scholarship on this issue, and there's a lot of legal arguments which I will not go into on this short call. But I will say that you know, one thing that we've seen is that, especially more recently, the federal courts have rejected that claim, and have made clear that the speculative nature of the potential possibility of someone you know, fraudulently casting a mail ballot down the road is not sufficient reason to prevent the expansion of mail voting. And one thing I think it's important to note is that people have been voting by mail for many years. This is not a new phenomenon. It's been called absentee voting in some states, and some states have different categories of absentee voting and mail-in voting. But some states allow all citizens to vote by mail, and have no distinction between mail voting and absentee voting. In practice, the practical effect of that distinction is really minimal, because in most cases, when you're voting by mail, you're following the same procedures throughout. You are requesting an absentee ballot or a mail ballot. You're filling out the ballot and you're submitting it by mail. And the same protections that apply to absentee voters will also apply, or should also apply, to mail voters. So that is the landscape of the litigation that we've been confronting, both the affirmative litigation and some of the defensive litigation. And I should leave a quick plug for a more fulsome summary of our litigation. You can check out Democracy Docket, and I think I'll leave the link in the chat here. But it has a more complete compilation of the cases that we're involved in the various states.
That'd be great. I wish we could get into the details of all of it, but I'm guessing folks don't want to be on a 24-hour Zoom call. But Avi, I was hoping now you could tell us a little bit about Virginia, because I know Sophia alluded to the litigation that she was involved in, that I think you're probably helping implement the subsequent changes to that. So can you tell us a little bit about that, as well as the challenges that election officials are having as they try to implement the new COVID rules?
Yeah, that was a very, very helpful consent decree, the League of Women Voters case that Sophia worked on that eliminated the witness signature requirement. After that, Governor Northam also called the General Assembly into a special session and, past early September, codified into law the fact that a lack of a witness signature is no longer material in terms of casting a ballot aside. So I saw a question about Purcell, which I'll let others on the call who are far better election lawyers than I handle, but at least that gave us a measure of comfort that we wouldn't be susceptible to similar kinds of challenges. But broadly, the issue in Virginia is one of administration. What we found, so each locality, each of the 133 localities prepares their own instruction with advice from the Virginia Department of Elections. But some of the registrars, I would say maybe, registrars vary in terms of their level of knowledge around the issues and the latest developments. Frankly, a lot of them are not lawyers, but I mean, they're all very well intentioned and try to do their best. But some of the instructions that went out maybe did not fully capture, the full extent of the way the law is right now, that, you no longer need a witness signature requirement. And as a result, we saw just a lot of confusion among voters as to, hey, so Democratic Party is now telling us you no longer need a witness signature requirement, but I'm looking at these instructions here that say, hey, you need a witness signature. And, the ballot envelope that I have to sign my statement of voter still has a block for a witness signature. So do I have to fill it in? Do I not have to fill it in? I mean, everybody is trying to do the right thing. I mean, that's I guess maybe my biggest takeaway in this job. You know, voters, they're like, hey, tell me what the rules are. You know, we'll do exactly what it is that we're supposed to do. We're trying to follow the rules, but it's just one of making sure that everything is in lockstep. I think in future years it will get clarified, and you know, just the first time around there are sometimes issues, but you know, I mean, that's just one piece of the broader election administration challenge. I'd say, you know, another one is just thinking through, and a big part of our day is thinking through what is the voter experience going to be like, not just for vote by mail, but, you know, if they do show up in person. You know, we've had some reports of localities, again, trying to do the right thing with COVID precautions, you know, tell voters, hey, you have to pre-schedule an appointment to come in and vote early. It's like, okay, well, you could foresee some issues with that, especially as you start thinking about longer lines, or, you know, what's the protocol when somebody arrives at a polling place without a mask? You know, I mean, you can't necessarily deny somebody the right to vote, nor should you, but how do you deal with that in a way that does not increase the line? I mean, on one hand, you could shut the polling place down after they're done voting, sanitize everything, and then open it back up. Or you could maybe do a curbside voting type deal. And you see just a range of different implementations. And I mean, again, everybody, I think, is trying to do their best after this cycle. There'll be a lot of lessons learned for future years. And, you know, at the end of it, it's never been as easy as it is today to vote in Virginia. But this is the first time everybody's dealing with it. And so there are just some challenges in thinking through, okay, well, how is everything actually going to play out? You know, are there going to be people, you know, taking temperature scans on election day before you walk into the polling place? What happens if your temperature is too high? Are they going to, you know, push you aside? So those are just the sorts of questions we are thinking through and asking. And again, I mean, the litigation piece is just such a huge win and so crucial. And then now it's just about making sure that we can capitalize on the gains of all of this great work that Sophia and Zoe are doing. So that's sort of the high level on that.
Great to have that perspective. I know that folks are really caring the most about, in a way, the battleground states. And Uzoma, I know you've been involved in litigation in some of that. And I know Sophia has, and it's been great to hear about Florida. And we've heard a little bit about Pennsylvania. But Uzoma, can you tell us about some of the other voting rights litigation in other battleground states, including Michigan?
Sure. So I'll talk a little bit about Pennsylvania, which is still in various stages. You know, new lawsuits get filed, you know, after one lawsuit gets resolved. I think the most recent development in Pennsylvania is the federal district court's dismissal of the RNC and Trump campaigns lawsuit, which challenged several procedures that would apply to mail voting, like, for instance, the use of ballot drop boxes that allow voters to drop off their ballot, return their ballot, you know, personally through a drop box rather than by mail. And in addition to Pennsylvania, which we've discussed, we're currently involved in litigation in Michigan. The state of play of that is that we obtained a preliminary injunction imposing several forms of very helpful relief, including an extension of the ballot receipt deadline, so that a ballot postmarked by the day before Election Day can be delivered up to 14 days after Election Day, and also allowing, you know, third parties to assist voters in returning their ballots in the last weekend before Election Day. Now that's currently on appeal. So that decision, not only is it being appealed before the Michigan Court of Appeals, but it's also being attacked in several collateral lawsuits. So there's one collateral lawsuit filed in state court by the state party, and another collateral lawsuit filed in federal court. And so I think that's similar to what we've been seeing in other battleground states and non-battleground states. I think these are very hotly contested issues, and whenever there is any relief, I think you can expect that it will be challenged, and that it will be contested up to the highest levels. And Sophia touched upon this, but you saw the amount of litigation that followed their very helpful consent decrees in Virginia and in Rhode Island. Rhode Island consent decree challenge went all the way to the Supreme Court. It's not typically the type of thing you see going to the Supreme Court in prior years. So the litigation has become has not only grown in scope, but has become much more contentious. And I think that we are seeing in some of these states, in both Pennsylvania and Michigan, we're going to be likely litigating till the very end. And in addition to those two states, there are other states like Missouri where litigation is ongoing. The reason I'm laughing is there have been some recent decisions coming out of Missouri that have made things a little bit more difficult, but for both me and Sophia. But I won't get into that. But in addition to Missouri, North Carolina, there's a lot of litigation that relates to both affirmative litigation that we filed to expand access to vote by mail, ensure individuals can exercise the right to vote, and also defensive litigation challenging some of the relief that we were able to obtain in state court. So it's a similar pattern in a number of these states, and I think that we have now found ourselves litigating in both state and federal courts as these laws are being challenged, and any relief obtained is also being challenged in any forum that is available.
Are there any particular cases that you anticipate going up to the court in time for the election or soon after the election? I realize it can be a little hard to predict, and there might be many such cases, and I would put that to both Sophia and Uzoma.
So I mean, I'll start in saying that we've seen cases go up to the court on emergency motions to stay pending appeal, and I think that's what we're most likely to see more of, as opposed to sort of the full-on appeal that you would typically expect. And what that is for those who aren't in the voting rights world is assuming, for instance, that there's a decision imposing an injunction on a particular rule, for instance, or extending the deadline for the receipt of absentee ballots. And that decision gets appealed to the Court of Appeals, and the Court of Appeals affirms. The litigants can further appeal that decision to the Supreme Court. And while the appeal is pending, they can file a motion to stay the injunction. In other words, to keep the relief from going into effect and from being implemented while the appeal is pending. That has the practical effect of preventing the relief that is obtained in the trial court from going into effect before Election Day. And that is what I think we're most likely to see. We've already seen that in a number of cases. The Supreme Court recently issued a stay of the injunction of the witness requirement in South Carolina in the Andino case, and we also saw the Supreme Court deny a stay of the Rhode Island consent decree, which Sophia can talk more about. So I mean, there have been some victories there at the Supreme Court. Congrats to Sophia on that. And there have been some bright spots, but I think that we are going to see more of those petitions to stay injunctions pending appeal, and those will be litigated. I think in each case, I think that's where we're likely heading, and those will be litigated to the very end.
That makes sense. We did have one question from the audience about whether or not the Purcell doctrine is going to control decisions made by the courts, given that we're now 22 days until the election. And I think they saw some hints of that in the South Carolina case that you just mentioned. And if you can also explain to folks what the Purcell Doctrine is for those folks who might not be studying election law as much as they would like to.
Sure. So the Purcell Doctrine is interesting. It's kind of evolved since it was first handed down, but it came out of a Ninth Circuit case that went up to the Supreme Court and the Supreme Court in Purcell basically stated that when litigating close to election day, one of the equitable factors that a court has to take into account is the proximity to the election and the potential for confusion that a court order may impose. And I think what was driving the court's ruling in Purcell is the risk of voter confusion, right? The risk that late changes into the election rules may result in voter confusion, and as a result may provide an incentive for voters to stay away from the polls, which would be counterproductive to a lot of the relief we're seeking. Now, the court presented Purcell as an equitable consideration, not necessarily as a jurisdictional rule, right? But it is a consideration. It is something that courts take into account. And one of the questions, one of the issues that the Purcell Doctrine, requires litigants to look at in some of these cases is what is the relief that we're seeking, and to what extent does that relief risk confusing voters? To what extent does that relief upend the electoral process or the electoral administration apparatus? So when you look at things like extending the ballot receipt deadline, for instance, that doesn't actually require voters to do anything different, because what you're changing is not how people vote. You're changing how those votes are counted after the fact. And we've seen courts, at least during the primary elections, we've seen courts grant relief, extending the ballot receipt deadline very close to election day. I think in Wisconsin, before the April 7th primary, we saw a federal court extend the ballot receipt deadline just merely days before the election. So it's not necessarily, all that is to say, it's not necessarily a given that because we're close to an election, Purcell bars relief. I think there's a lot more to it. And when you don't have that risk of voter confusion, and when you don't have that risk that the relief may prevent voters from appearing at the polls, when you're really just challenging the way that, not the way voters vote, but the way ballots are cast. I mean, I think you're talking about a different set of rules, and on those factual circumstances, Purcell doesn't speak to those issues. At least that would be our view. So, but I'm sure Sophia has thoughts about this as well.
No, I and obviously completely agree that Purcell is just one consideration of many. The other thing that I would add in some of these cases is that Purcell was also on a preliminary record. It wasn't fully litigated, and so there are considerations in that scenario that wouldn't be in play, for example, if you were post-trial, which has been the case for some of our cases as well, where we've actually had a full-on trial. Now, and so once you've determined that there is a constitutional violation, let's say, of somebody's right to vote, should you just let it lie if there is some sort of simple solution that could be put in place that wouldn't, as Uzoma said, do anything to discourage voters, where voters aren't really doing anything different. Their ballot is just being counted versus discarded. And so that's another thing that, at least for some of us, pushing to an actual trial has been part of that calculus. Now, one of the challenges I think that we've been facing is that, at least with respect to the first round of stays given during the primary, there's just been there's no opinion associated with those stays. And so I think a lot of people have interpreted that as, well, it's just Purcell, and that's what's barred it. But even in the recent South Carolina decision, there wasn't a majority opinion about why that case was stayed. And so you can kind of read into it as much as you want to, but that is one of the challenging pieces of this for lawyers, is to say, well, what can we tell you if you're not telling us what the issues are? And that's been a little bit frustrating, I think, for voting rights advocates in terms of and judges too, I think, trying to navigate this election season particularly.
Well, we now are 22 days until the election, so I'm sure some of the folks who are tuned in would like to hear, now based upon all of this, and now that we have a better understanding of the litigation, what are folks to do? Are there any practical tips in order to guarantee, or at least make it much more likely, that folks' votes will be counted? So Avi, since you're involved in the administration side of things, in Virginia, are there any tips that you have for voters to make sure that their votes are indeed counted?
Yes, certainly. Well, I mean, some of the programs that we implement are direct voter-facing, assistance tools that voters can use. So we run a hotline as an example, where oftentimes we're working through with a voter that has a problem or a question, and those are votes that probably folks may not otherwise be able to cast a ballot. So one thing you could do, I know APABA is nonpartisan, but if you're inclined to get involved with democratic voter protection work, I'd encourage you to visit joebiden.com/voter protection. There's a lot of volunteer work that you could do right now to help make sure that everybody's vote is counted. Volunteering on the hotline is one of them. We need AAPI language capacity specifically. There's a large Vietnamese, Korean population, Mandarin Chinese as well. So that if you know of folks who are interested, please direct them to joebiden.com/voter protection. The other thing I'd say is, and some of this is just as simple as making a plan to vote. And vote early, vote by mail, or whether you want to vote in person. Any way you vote is fine, right? Just make a plan to vote today, and go call your family, call 5 of your best friends, tell them, hey, how are you going to vote? And if you need some resources on doing that, iwillvote.com is a one-stop shop in terms of registering to vote in any of the states, or voting options for, you can game out, how do I vote by mail, or how do I vote in person? Where do I vote in person? However you vote, voting is easy and convenient. Just make a plan to get it done.
We also had a question from the audience about drop boxes in Texas in particular. So I'm not sure if any of you know offhand, but I think folks were wondering whether or not there is indeed access to drop boxes in Texas, or how available those are, and whether or not those are trustworthy.
So I believe that's still the subject of litigation, some fast-paced litigation, and there have been some developments over the weekend. On Friday, I believe, if I have the day correct, I think we obtained an injunction from a federal court that enjoined Governor Abbott's order with respect to drop boxes, eliminating drop boxes. And then I believe on Saturday, the Fifth Circuit entered an administrative stay of that injunction. So, all that is to say, stay tuned. It's still it's still being litigated, and things are fast moving. So these types of litigation, especially with respect to drop boxes or ballot security rules or rules that affect how people vote, are usually resolved definitively very quickly, because people need to implement the relief. So stay tuned, and updates on Democracy Docket.
Great. Sophia and Zoe, do either of you have recommendations for folks in light of the fact that things are changing constantly? Do you think it's better to vote in advance or in person, or do you think that any of the above are acceptable depending on state rules?
I'll let Sophia take that one first.
So, I mean, I absolutely agree that you should try to make a plan, and to the extent that you are confused at all about the current situation, there are a number of different resources. Avi mentioned some. We have some on our ACLU voter site for mail voting, the nonpartisan election protection hotline, which is another place where you could also volunteer if you want to be a volunteer with a nonpartisan group that's just out there to help make sure that voters are able to access the ballot. That they are banning those lines and trying to answer a lot of these questions. So if you have any questions, there's certainly ways to get that answered. I think in a lot of places, the rules are clear about at least this initial phase of either voting in person, when you can vote in person, when that starts, early voting, or if you can, when can you request your mail ballot, and so forth. And so the recommendation that Avi had of making a plan now, going to vote if you can as early as possible, I think will just alleviate a lot of pressure on the system as a whole, and make sure, and it ensures that your ballot will be counted, gives you time to check in on that if you're mailing it, track it, and so forth. So encouraging folks around you to take advantage of these early opportunities, I think is a great thing to do. But I know a lot of people don't think about voting until election day, and that's just going to be different this year. We really encourage people to start thinking about that. If they haven't already cast their ballot, to think about that tonight, tomorrow, and get it done as quickly as possible.
I know we're already reached our hour, but just if I can impose upon you just for a minute or two longer, I'm wondering if folks have any recommendations on getting involved. I know Avi and Sophia, you've both mentioned some resources. I'm not sure, Uzoma, if you have recommendations on how folks can get involved, but we have a lot of lawyers, I'm guessing, who've called in. Is it too late if folks have not yet been able to engage in voter protection work for folks to now get involved? And do you have any recommendations on how best to do that?
So it's absolutely not too late to get involved. There are a number of different resources. You know that there's an organization, We the Action, that helps pair attorneys to important causes. I know that there's obviously an election protection hotline, and and there are various election protection efforts that I have volunteered for over the years. That do a great job of assisting voters. Becoming a poll observer, I think, which is something that Avi mentioned, I think is hugely important. And I've done that as well, over the years, and just being able to have folks on the ground who know what to look for and can assist in gathering facts and reporting information is hugely important. So it's definitely not too late to get involved. It's definitely not too late to volunteer. But as far as voting, I think I echo what Sophia and Avi have said. I think that now is a good time. Many of us, I think, including me and you, Erica, and live in DC, where the election officials have adopted many of these reforms that we're actually trying to implement already. So it may be a little bit easier, but that's still no excuse not to vote right away.
Well, thanks to all of you very much for this really illuminating and also really important conversation. We really appreciate you taking the time. I know all of you are really busy, as we are, only 22 days until the election. I want to thank everyone for tuning in, especially on what is, for some folks, a holiday. Thank you for joining the program, for taking the time this evening. Thank you, Sophia, Uzoma, and